what you're going to be urging, Mr. Salve, you are opposing the reference, or what are you saying?
Yes, my lord. My lord, in fact, I'm opening by telling you my submission is that the issues when they were framed, we had mentioned this, but the issues which have now and the events which have now transpired are such that there is no need for this reference. And in fact, the reference would be contrary to the writ petitions themselves. That's what I propose to point out. I open by saying, my lord, we heard yesterday impassioned plea by Mr. Sibal saying how the defection law has failed to curtail defection. And my lord, yes, of course, ultimately no law can completely fill in the gap left by morality. So that's where we are. If Mr. Sibal said the speakers have failed to rise to the occasion, well, I don't think there can be any cavil about that, the kind of cases which have come. But also, my lord, equally, this we should always remember this was an anti-defection law, not an anti-dissent law. The challenge and the criticism include right from the late Mr. Palkhiwala, who was one of the great votary of political morality. Always the criticism of such law also used to be that this becomes an anti-dissent law. And that is what this is being converted to today. If I give your lordships 5 or 6 dates, your lordship will see that none of these petitions survive. Unless your lordships, and that is not really even for a bench of 5, unless your lordships come to the startling conclusion that under 142, applications pending before a speaker can be transferred to this court and tried. And that's one of the prayers in one of the writ petitions. Or an even more startling conclusion saying the moment there is a disqualification petition filed, the candidate stands disqualified until he is requalified by rejection of the dissent petition, by the defection petition. But those are not matters, one of which 5 of your lordships will refer to 7. What your lordship is today concerned is with the Nabi Mirabia problem. I will not take any time reading that judgment beyond saying that there was a serious problem in that case. There is a strong argument that you should not hold speakers to be in suspended animation merely because a dissent removal is pending. But Justice Misra particularly, Malad, brings out the counterpoint. Suffice it to
Justice Mishra brings out their voice. We lost
counterpoint. The counterpoint.
the counterpoint.
Yes. And I'm only saying this for the reason these are delicate constitutional issues which should be resolved in a Fitch case where the question arises. Does the question arise in this case? And the answer is a resounding no. And let me tell my lord why. It is, my lord, in our counter affidavit, if your lordship turns to page 494 of volume 1, convenience compilation. What exactly happened and what has happened and where are we today? The only petition in which Nabi Rabia today is a live issue is a petition settled by Mr. Kamath, who perhaps realizing the folly of his ways has argued that Nabi Rabia should be reversed. It's a petition by a group of people against whom the Shinde faction has filed defection petitions. They have come to your lordship saying because of Nabi Rabia, because we have applied for removal of the current speaker, do not allow him to continue. Now, if they say the judgment is wrong, all they need to do is withdraw their petition. Look at that, my lord, for a minute. Because I think that's what is important to know. In such a delicate constitutional issue, your lordships are embarking on a journey which has no destination. Page 494, my lord, we give the dates.
How 494 of?
Of compilation 1, volume 1. My lord, PDF page 494. 497, sorry. I hope I've got my PDF pages right.
It's a common reply of the
It says convenience compilation volume 1.
It starts on the top as common.
Factual matrix. Correct. That's that. Factual matrix मिल गया?
Have your lordships been able to find that?
Convenience compilation was
Where it says factual matrix.
Well, at the first sentence in that is in a sub paragraph 7 saying on 21st June 22.
Chief, it is. Yes, Mr. Salve. Whose counter is this?
This is Malad from our side.
Right.
21st June 22. It starts by saying it came to the knowledge of the answering respondent. Answering respondent here is the current chief minister, Mr. Shinde, and other members of the Shivsena legislative party. They have used SSLP, the acronym for that. That a minority faction, only 24 out of 55 MLAs, attended an unauthorized meeting, passed a resolution to remove the answering respondent as leader and appointing Ajay Chaudhary as the group leader. Then, next para it says on 21st June, 34 MLAs of the SSLP passed a resolution reaffirming that the answering respondent was appointed as a group leader, etc. The resolution was clearly stated that appointment of Ajay Chaudhary is illegal. Now, this is all the wrestling going on with the appointment of the leader of the party. This is all happening on 21st June. Para 10 says on 21st June, 34 members of the Maharashtra Legislative Assembly issued notice under Rule 11 of 179 to Mr. Narhari Zerwal for the motion for removal of the Deputy Speaker. Now, this motion was never carried to fruition. In fact, he continues even today as Deputy Speaker. 24 June 22 is the next event, small 11. Answering respondent came to know that Secretary Maharashtra Legislative Secretariat communicated that a request made by the petitioner to recognize Ajay Chaudhary has been recognized by the Deputy Speaker. So, the other faction's person is recognized as the Deputy Speaker. Then, 22nd June, Sunil Prabhu, claiming to be group leader, issued notice. There were cross notices to each other. Your lordship may drop down to page 501 PDF, para 14. In a meeting held on 22nd June of the Shiv Sena, which was held by 14 out of 55 MLAs, held at Varsha Bungalow, it was resolved that those members who did not attend the meeting should be disqualified. Now, my lord, the submissions before your lordships have proceeded on the footing that there is a disqualification petition by which all the MLAs will go. What your lordship had not told was only 16 petitions were actually filed. So that's the number in count. Then, my lord, small 15. Accordingly, on 23rd June, Mr. Sunil Prabhu filed a petition under Rule 6 of the defection rules against the answering respondents and a few MLAs for not attending the meeting on 22nd. Now, my lord, please see the next paragraph 16 at 502. And this is why petitions were filed in this court. Forget the Navim Rabia point. Answering respondent along with few other MLAs received summons on 25th June by principal secretary for disqualification, etc., etc., whereby the respondent and others were directed to file a reply to disqualification petition on or before 27 June. Now, my lord, this is even against the rules. You have to give a minimum time. The speaker was rushing ahead. Then, my lord, on 26th July, should be 26th June actually, the answering respondent and other MLAs filed. Therefore, my lord, this was the original petition filed. And in this, my lord, para 18 says on 27 June, this court said we extend time till 11th July. Now, this court did not say that the speaker shall be in suspended animation. By extending the time to file a reply and by compelling these people to file a reply, the court has in fact allowed the speaker to function. Now, we were therefore given time up to by the court till 11th of July. In the meanwhile, my lord, on 28th of June, the Maharashtra asked Mr. Uddhav Thackeray, the chief minister in office, to prove his floor majority. And on 30th June, my lord, a session is convened on which Mr. Thackeray is to prove his majority. On 29th June, Mr. Sunil Prabhu moves your lordships asking for a stay of the session. The court declines it. When the court declined to stay the 30th June meeting, Mr. Thackeray resigns.
So there were two, the actual scenario was this. By our order of 27th of June, we had
Yes.
extended time until the 12th of July. to submit
11th of July.
responses,
Sorry, 11th
The
July.
disqualification notice.
12th July.
Yes.
But in the meantime, as a result of the direction of the governor, the floor test was to be held on
Yes,
30th. In other words, the floor test would take place without the speaker applying his mind to the disqualification.
Correct. Correct. They came to your lordships and said, stay this meeting.
Right.
Your lordship said no. Now, the legality of that meeting is no longer an issue because Mr. Thackeray resigns.
This one.
So there was no meeting on 30th June. So, my lord, the question of the defected or the challenged 16 MLAs voting on 13th June did not arise because there was nothing on 30th June. Mr. Thackeray walked away. So even that question of law doesn't arise. And on that date, I want to give your lordship admitted figures. There are 288 MLAs.